So thank you all for jumping on. If you guys can all just stay on mute for the duration of the presentation, and then you can come off and answer or ask any questions after, that would be great. Or you can feel free to toss any questions in the chat throughout, and then Leonard can address those at the end. So I'm just going to toss it over to Leonard, who was with Collins Law, and he's going to talk to you guys a little bit about insurance interruptions during COVID.
Great, thank you, Lindsay. Thanks everyone for joining us this afternoon. I hope that you will find this presentation informative. We've been watching this issue for pretty much the duration of the situation that we're dealing with right now. It came across our attention in a number of ways that we'll talk about, but we wanted to share this with you today because we think that this is becoming the not only an emerging issue that's of vital importance to the business community at the moment, but is something that will likely be with us for some time. We've been watching it closely for some of our clients, and what we're going to talk about today is less about specific strategies or things that we're looking at, but more general information. That's largely because these situations are very fact specific, and it depends on the specific policy language that's involved. At the same time, many of these policies have very similar provisions. They're built on standard forms and the like, but despite being on standard forms, there is a lot of variation among the policies. And so it's important that you understand at the outset that not only is insurance coverage a sophisticated and complicated practice, but that it does depend on the facts and circumstances in individual cases and the language in the policies. Whenever you're dealing with an insurance coverage issue, it's important that you read the full policy. And it can be difficult to know whether you have a full policy. You might think you do, but if you have a situation like this, one of the first things that you want to do, besides contacting counsel, is request a certified copy of the policy so that you know exactly what you're working with. It has happened in situations where an individual thought that they had coverage, and we looked at it and we requested a policy from the broker, and lo and behold, additional endorsements popped up that actually changed the coverage analysis. So it's important that you make sure that you have the full policy in front of you, and that you're starting from that in the very beginning. The situation that is confronting us is confronting the whole country and the whole world, of course. Here in the US, we have a particular situation. I'm not going to go into the business slowdowns and all of the economics. We're all aware of it. We're all living with it. What's interesting about it, though, is how the insurance industry is looking at calculating the potential business losses during this time period. Industry estimates have been anywhere from 250 to well over 400 billion per month. That's not only a lot of money in the abstract. We also have to consider that against what the insurance industry takes in premiums for this line of business, which could be as little as 6 billion per month, and possible reserves set aside only 800 billion. That's a lot of money, again, in the abstract, but if you look at it in terms of what the potential losses here are, that means that if they were required to cover all of these losses, they only have about 2 months of runway. And we're well on our way to that time period already. And so it's not surprising from my perspective that the insurers are denying claims. Sometimes we're seeing claims being denied without apparently any investigation being performed. And so a lot of business owners are finding themselves not having insurance coverage when they thought that they'd had it. Should say from the outset that I represent policyholders and small businesses. So today, I don't know that I will be in the position of giving what some people would say a fair and balanced view of the situation. The clients that we represent are folks who have paid premiums for many years and thought that they had coverage, only to find out that under the certain circumstances presenting themselves, that insurers are denying their claims. So what we want to talk about today is essentially a public policy push that has come from the insurance industry. We started seeing articles and industry trade literature some time ago, weeks ago, at the very beginning of the COVID crisis, where they started seeding the internet with articles written by defense counsel and the like, sort of massaging public opinion in a certain direction, so that everyone would start thinking that there was no coverage for these claims. What has gone on in the time since then is a great deal of investigation and research by policyholders' counsel to test those assumptions, and in a number of ways have come up with good arguments that policyholders have options for pursuing coverage. At the same time, it may well be that litigation is not the answer here, because there are a number of initiatives being pursued at both the federal and state level, legislative proposals and other kinds of proposals to deal with this problem, because in some sense, at least if you believe the insurers, they claim that this may be, if they had to cover all of this, it would create a risk of solvency for the entire industry. So there are a number of different ways to think about finding coverage in these cases, unlike the traditional situation where in a normal situation like this, it'd be a simple matter of deciding whether or not to file a lawsuit. But in this environment, there's a lot more moving pieces that you might not otherwise have to think about. And so that includes not just the policyholder and the insurance companies. Other players include agents and brokers, and the state government and the federal government. A word of note about insurance agents and insurance brokers. If you have insurance, and if you're on this call, you probably do, you worked either with an agent or a broker. In a situation like this, it's important to know whether or not the folks through whom you procured your insurance are operating as agents or brokers. And the reason is, if you are in a dispute with your insurance carrier, the agents, generally speaking, have interests that are aligned with the insurance company. And brokers can sometimes have interests that are aligned with the policyholders. Each of those depends, again, on the facts and circumstances, but just be aware, to some extent, when you're talking to the agents and to a lesser extent the brokers, that they are being fed certain information from an insurance carrier, and you might want to take that with a grain of salt. The state government is playing a role here for a variety of reasons. In most states, there are insurance regulators that play a role in regulating and approving the operation of insurance companies in the states. There are also a little over half a dozen different states so far that have introduced legislation requiring insurance companies to pay these claims, or that would require it if that legislation is passed. We'll talk a little bit about that. And there's similar activity going on at the federal level. So we have reason to think that these claims and the business losses that are being incurred is putting the insurance industry on edge. One of the first things that we saw happening as the situation began developing almost 2 months ago was in a different part of our practice area. I focus on business disputes, but other attorneys in my firm handle personal injury litigation and environmental litigation. And we noticed a significant uptick in the number of adjusters and defense counsel trying to settle cases with us. And this happened shortly after sort of the big dip in the market. And we weren't that surprised by that. At first we thought, well, insurance carriers have their funds tied up in the market. There's a lot of uncertainty in the market, and sophisticated players sometimes will pay a premium in order to obtain some certainty in their scenario. The next thing that we saw happening on a widespread scale was insurers denying business interruption claims across the board. Sometimes they're denying those claims the same day that the claims are submitted, and raising a real serious question how they could, the insurers that is, could perform a good faith investigation as is required by state law. The thing that tied those two observations together for us was we read between the lines and talked to some folks that we operate with, and came to an understanding that the insurers, we believe, are trying to settle cases in order to divert their resources to defend claims for business interruption losses. We think that's kind of a big deal because it means that they are shifting and pivoting their focus for one of their largest exposure areas. And so it underscores the point that this is a big deal to the insurance industry. Let's talk briefly about what business interruption insurance is not before we talk about what it is, because some people confuse business interruption insurance with what is properly known as event cancellation insurance. Event cancellation insurance is a different product that provides coverage for cancellation of usually scheduled events. So for example, the Wimbledon tennis tournament stands to receive a good payout because years ago, after the SARS outbreak, Wimbledon started paying for pandemic insurance coverage under an event cancellation insurance policy. And although those kinds of policies have had some issues in this environment, it has been less of a problem than traditional business interruption insurance. Many businesses don't have event cancellation insurance, some do. We're working with a client that has both, and while their claim for business interruption has been denied, they do stand to receive some payout on event cancellation insurance, so that's less of a problem for them. Business interruption insurance, by contrast, is meant to cover your lost business income and get your business back to normal after there's been a disaster. There's additional coverages that can go along with this if the policyholder decides to add them. So for example, while the typical business income coverage pays for your lost business income while your operations are suspended, once you resume operations, that is, once your property is restored or should be restored, the coverage terminates. But if you've purchased an extended business income coverage, then you may receive income for some period after that, say 60 or 90 days, depending on the policy. And it will cover you up until a time that either the time runs out or your income returns to normal. There's a related line of coverage called contingent business, which provides lost income when there is loss or damage to the property of your suppliers or customers. And that is a kind of coverage that may also be relevant when we're talking about the COVID-19 crisis. Civil authority is another kind of coverage that is being invoked and denied by the insurers in this situation. It relates to business income because it covers lost business income when a government denies access to the policyholder's property as a result of loss or damage to property at another location, usually nearby. It's important to note that all of these provisions are typically part of a commercial property policy. We've seen some situations where policyholders are trying to argue with an insurance company based on provisions in a general liability policy. Generally speaking, that's not going to get very far with an insurer, since those kinds of policies are meant to protect you in case you become liable. So for example, if someone slips, trips, or falls on your premises, generally your liability policy will be invoked. And what we're talking about here is your property policy. But if the distinction seems unclear to you, or you're having a hard time understanding your policy, don't feel bad. It's not your fault. We blame the insurance companies who over the years have made these policies very complex and difficult to understand. We have a note here on the slide. There's a comment from a longtime insurance professional who was tasked with researching whether and to what extent the courts actually expected policyholders to read their insurance contracts. And as you see, it was only about half the time that the courts expected that would actually happen, or that the insureds even should. And part of the rationale was that the insurance policies were so complex that an insurer might not even understand it uninsured rather, might not understand it if they even bothered to read it. On the screen now, we have a sample clause from a policy that provides coverage for business interruption. It says, we'll pay for the actual loss of business income you, the policyholder, sustain due to the necessary suspension of your operations during a period of restoration. The suspension must be caused by the direct physical loss or damage to the property. The loss or damage must be caused by or result from a covered cause of loss. I've underlined some of those words there. We'll talk about business income in just a moment, but for now, just understand it's the income of your business. A suspension, some people will think, well, I haven't been shut down, so my operations haven't been suspended, but that's not necessarily true. Under many of the policies, the word suspension is defined not to include not just a shutdown, but also a slowdown. So if you're a restaurant and your dining room has been closed, your operations have slowed down, not necessarily shut down, but you might still qualify for having a suspension of your operations. A period of restoration, that usually means a time period, the date of the loss. So for example, if we're talking about the date of a closure, sometimes there's a 3-day waiting period. You can think of that kind of like a deductible. And that period lasts up until the property is either restored or should be restored with reasonable speed. One of the big issues in these cases is going to be the requirement that there be a physical loss or damage. We'll talk about that at some length here in a couple of minutes because it's a key issue with the insurers claiming that COVID-19 in the presence of a virus or the suspected presence of a virus doesn't constitute a suspected or an actual physical loss or damage of the property. So the purpose of having business interruption insurance in the first place is to put you back in the same position you'd been if there hadn't been a disaster. And the basic calculation is that it provides for your net income and your continuing expenses, plus any extra or additional expenses you may have incurred that you wouldn't have otherwise had to pay for in the result or without the disaster having occurred. So ordinary expenses, continuing expenses would include things like ordinary payroll, your employee benefits, workers' comp premiums, but you got to read your policy carefully because often it does not provide payroll expenses for high-level officers and sometimes even managers, and certainly not independent contractors would rarely be covered. In practice, valuing your loss can be somewhat complex. So the formula itself is rather simple, but there's a number of other factors that we have to consider. And one of the big ones that everyone who is making one of these claims should be thinking about is mitigation. Under most policies and under the law, most policyholders will have a duty to cut their losses. And that includes things like finding alternative ways to put your resources to value. So for example, when Nike pivots and starts making face shields, or Brooks Brothers starts making masks, that's a kind of mitigation. Local restaurants that didn't do delivery or takeout, now providing those services, that's a way of mitigating their losses. And that's a good thing. Not only does it make good economic sense, it's also a duty that is imposed on the policyholder. And if policyholders don't do that, one can expect that the insurers would look for a way to chip away at the claim and suggest that policyholders didn't meet their demands. Other considerations that have to be thought about when you're making a claim or valuing the claim at some point. There may be pent-up demand that may cause a spike in sales when the operations are restored. The insurer would probably say something like, well, we have to look at what customers would have done had there been a crisis, but what if you hadn't been required to suspend your operations? If the market had gone down and people would have consumed less, the insurer would say that that's something that has to be considered. The key to all of this is keeping good records. You want to track your records, track your expenses rather, document it. And if you have extra expenses that you incurred that you wouldn't have otherwise incurred, try to track them separately because it'll make it easier later to have them be separate items as part of the valuation and the accounting. we've already talked somewhat about how long the period is covered. The period of restoration, there may be a policy limit on it. A fairly typical one is that it'll only provide coverage for 12 months, but then there's also at times policy limits in terms of dollars that apply. You've got to look at your policy to make sure. Sometimes, depending on the state, and there's case law suggesting that you can stack coverages to obtain additional time. So for example, one of the arguments that will be made here by policyholders is that civil authority coverage applies and traditional business income applies. So civil authority coverage may cover the first 4 weeks, and then business interruption insurance kicks in after that. There's case law saying that that's a valid way to go about doing it so that the policyholder gets the benefit of both time periods. So there's 3 main reasons why during this difficult time that insurers are denying coverage. The first is they're saying that the presence or suspected presence of the virus doesn't constitute physical property damage that's necessary to trigger coverage under the policy. The second main reason that we've been seeing is that many of the policies contain a virus exclusion that purports to exclude any loss caused by a virus. And thirdly, the insurers are saying that civil authority coverage doesn't apply, even though there have been orders shutting down non-essential businesses or otherwise restricting use and access to various businesses because of either of the first 2 reasons, lack of physical property damage or the virus exclusion. So in almost all of these property policies, there is a threshold requirement that there be a physical loss or damage to the covered property. And the insurance company says, this is a quote from an actual denial letter at the top. It says, it's our position that the closure of a business as a health and safety precaution, when there's been no actual contamination of that property by a harmful substance, does not meet the policy's requirement of a direct physical loss. Well, the policy says it'll pay for physical loss of or damage to covered property. So I think that policyholders would and have argued in the litigation that we've been seeing that hey, the presence of a dangerous substance in a property is a physical loss or damage. And moreover, this doesn't, the language itself doesn't require physical damage. It requires the loss of the property. And there's case law indicating that the presence of a dangerous substance in a property constitutes physical loss or damage. There's case law here in Illinois that stands for that proposition, and elsewhere as well. For example, there's cases finding that the presence of E. coli made a home useless and therefore satisfied the requirement of physical loss or damage. There's also case law saying that the loss of the use or access to a property for its intended purpose is also sufficient to satisfy this requirement. There's an interesting question though, which is in the cases where the insurers are denying coverage outright without even conducting an investigation, how they're determining that there's no contamination or no loss or damage, particularly when you have the NIH advising that there's a risk of contamination anywhere and everywhere, and you have executive orders in Illinois and around the country that are referencing the widespread, not just widespread risk, but also actual loss and damage to property. And I don't want to focus on property here to the exclusion of the important injury and loss of life that's occurring. But in terms of finding coverage for business interruption losses, it's important to remember that these are commercial property policies that are at issue. To that point, here is an excerpt from Governor Pritzker's declaration of the state of Illinois as a disaster. He expressly recognizes that the circumstances have resulted in the occurrence and threat of widespread and severe damage, injury, and loss of life and property. In his executive orders, he also referenced the risk and the virus's propensity to physically impact surfaces and personal property. So this highlights the property impact and the loss of property that's being suffered by various business owners. And this comes out of, for example, in the first one here, you see there's a reference to bars and restaurants, which is a large segment of the business population that's really suffering right now. Other examples include fitness centers and gyms and things like that that have had to shut down entirely as a result of these conditions. There's a very recent decision in the last week or so coming out of Pennsylvania that I wanted to share with you on this particular issue. So this was an interesting case because there you had a group of business owners who challenged the executive order requiring them to shut down their businesses. Now, it may well be that there may be a group of business owners on this call or in the chamber generally who would have liked to have joined in a suit like that, challenge the executive order that required them to shut down their business. Well, in Pennsylvania, the business owners were not successful, and the Pennsylvania Supreme Court held that the executive order was an appropriate exercise of government authority in light of the disaster. The reason I bring it up here is because there's interesting language from the court here about the disaster and the widespread physical scope of it and how it relates to property, because the way that the virus can live on surfaces for a period of days, there's some disagreement about that, but the point is, because it can live on surfaces, therefore any location, including the businesses where two or more people can congregate, is within the disaster area. And that tells us that any location, you can reason from this that any physical location where there's a transaction of business is subject to property loss or damage. So that's an important development in this fight that's brewing between policyholders and insurance companies. The second big point, and before we go on to this big point about the virus exclusion, I should say that one of the things that we've been seeing in denial letters is that the insurance companies are almost tacitly admitting that they have some weakness on the first argument, which is that there's no physical loss or damage to property, because they've been wording it in a very tender way without trying to take a strong position on it. And that may be because when they're writing those letters, they're concerned about falling prey to a bad faith claim, because if they take an unreasonable position on that, they open themselves up to a bad faith claim, which in the event of litigation would allow a suit not only to obtain coverage, but also for attorney's fees and an additional penalty. So the second point that insurers are making is that in many of the policies that have come out in the last 10 or 15 years, there's a new exclusion called the virus exclusion. And it says, we will not pay for loss or damage caused by or resulting from any virus, etc. Well, this exclusion has an interesting history, and it's an example of why policyholders shouldn't just take the insurance companies at their word, because the insurance companies are acting as if this language, this exclusion, is the end of the story. That even if there was loss or damage, property damage, that it was therefore it was caused by a virus, and so there's no coverage. Well, the history of this exclusion shows us that there are some questions about how it came about and whether enforcing it would be unconscionable, because essentially the insurers misled or mischaracterized the effect of the virus exclusion when they got it approved back in 2006. So the virus exclusion was inserted after the SARS outbreaks in the early 2000s, starting in 2003. And in 2006, the insurance industry proposed this new exclusion. Now, the way the insurance industry works is when there's new exclusions or changes that are widespread like this, they circulate the proposed language among state insurance regulators who either approve or disapprove of the amendments. What we have here on the screen is the first page of a circular that was circulated among the insurance industry and the regulators in 2006 for the virus exclusion. And this is a copy of the circulation by the insurance service offices, which is a sort of an industry repository of standard insurance forms. one of the things that they said in this circular and in others around the same time was that the virus exclusion, although new, really wasn't changing anything, because they said that there was already a pollution exclusion that excluded loss due to contamination. And so all we're really doing, essentially the gist of this says, is we're clarifying the scope of the coverage. Well, a couple of interesting points on this. First, case law, including here in Illinois, indicated that the pollution exclusion was intended for traditional environmental cleanup, not necessarily for things like virus exclusions and the like. And the second is that when they were proposing this new virus exclusion, the industry said, because we're really just clarifying the scope of it, we don't think that policyholders deserve a reduction in their premiums. Well, this wouldn't necessarily be the first time that the insurance industry has mischaracterized the way that a new exclusion should be interpreted. In the 70s and 80s, the industry circulated some characterizations about a pollution exclusion, and that the policyholders weren't due a reduction in their rates. What happened was the courts decided to hold the insurance industry to their representations, and they ended up paying for it. And we think that there's good arguments that are being made right now that are going to lead in the same direction, which is essentially that the insurance industry should be barred from enforcing this exclusion because of the way that they snuck it through the regulators back in 2006. So this is an example of why it's important to understand that just because the insurance company has taken a position, that doesn't necessarily mean that it's the end of the analysis. The third piece of this, and there are a few other arguments that we're seeing from the insurance company, but the third big one is civil authority coverage and why it doesn't apply. Civil authority coverage covers losses when there's damage to property other than the policyholder's property. So for example, if there had been a spill of a toxic material at a business next door to yours and the government prevented you from accessing your facility, that might be a claim you would make for civil authority coverage. Well, here, the insurers have been saying that there's no civil authority coverage because A, there hasn't been a loss of or damage to any property at all. And if there was, that it wasn't within the area covered, which is, sometimes it'll say, I think in this case here, it has to be within 1 mile of the covered property. So essentially the insurers are taking the same physical property damage argument and applying it to avoid providing civil authority coverage. And the answer to that that's been taken in litigation is to point to the executive orders and the disaster proclamations that have showed how extensive the loss and damage to property has been. And there is a case pending right now in California that was filed by Thomas Keller, the famous Michelin star chef who has possibly the most famous restaurant in the world, the French Laundry. And the allegation in that case has been that the entire public space has been lost or damaged. And we have similar language in the proclamations and orders here in Illinois, where there has been recognition of cases throughout the state of Illinois, as well as proclaiming the entire state a disaster area, recognizing the impact of the virus on surfaces that resulted in the shutdown or slowdown of various businesses. And so we think that this is an argument that's developing that may trend towards helping establish coverage under the civil authority provisions. Let's talk a little bit about nuts and bolts of managing a claim. every policy imposes basic obligations on policyholders. And those three basic obligations are: you have to notify the carrier, you need to take steps to minimize your losses, and you need to keep good records. The notification requirement is a very important one, because many policies will say, for example, you have to give prompt notice. Sometimes they may say immediate notice of the loss. Sometimes it'll be a particular time in which you have to give loss. You need to read your policy to find out what it is. But if you don't timely make a claim, the insurer will say, or may say, that they've been prejudiced and that they're not able, or that their own duties are lessened therefore. And to the extent that that can be avoided, that's something that you want to avoid. Under the certain circumstances that we have now, most businesses that have been suffering losses have been making claims. At least those that we've been talking to have. There are a few I know of that are concerned about making a claim because then they're going to have a record of having made an insurance claim. Under the current circumstances, that's probably less of a legitimate concern than it usually would be. Of course, individual situations vary. Don't forget that every policy requires you to mitigate, cut your losses, and of course, keep good records. So another piece of the puzzle is what's going on legislatively. At the federal level, they're kicking around what's been called the Pandemic Risk Insurance Act of 2020. This isn't getting a lot of attention at the moment. It's getting some because everyone knows that this business interruption loss issue is going to become one of the major, if not the major issue that we grapple with once we have gotten our hands around the health and public safety issues. Right now, more attention has been given to the CARES Act and the Paycheck Protection Program, but this will be something that's becoming of major attention sometime soon. This proposed legislation would require insurers to pay for business interruption losses from viral pandemics or forced closures of business by government. And to the extent that there are exclusions of losses due to virus, it renders those exclusions null and void. Now, one of the reasons that it's important to have this done at a federal level as opposed to a state level is that while there are similar proposals being floated by various states, there's a serious question about whether or not the states can actually make those requirements because of limits imposed by the federal Constitution. So our Constitution has a clause that limits states from making new laws that impair the obligations of a contract. In other words, it's unconstitutional for a state to write a law that retroactively changes the contractual obligations of parties. And so there's been a lot of interesting legal debates going on about whether or not any of these proposals at the state level could actually stand up to the constitutional requirements. I think the consensus has generally been that they cannot, although there's been some interesting arguments made. But that's why it's important to have a federal proposal, because the federal government doesn't have the same constitutional limitation that the states do. In theory, the federal government can pass a law that would require a retroactive adjustment of contractual obligations. The real question that comes up after that, and I'm afraid I don't have the answer for it on this call, is how is this financed and funded? Very likely there will be some taxpayer funded backstop for this. That almost has to be the answer here because there's not really any other solution. What could end up happening in these cases is that rather than extensive litigation, it is entirely possible that there will be one or more funds set up, funded partially or entirely by the insurance industry with perhaps some input or funding from state and federal government that results in funds that are administered sort of like what happened after the hurricanes in recent years, or after the BP oil spill. And so instead of pursuing litigation, it may be an alternative for some policyholders to file claims with these funds and seek compensation that way. Which sort of leads to the discussion of what's next and what's coming around the horizon here. If this were a traditional situation where let's say we have a one-off client in a situation like this where there has been a denial of coverage, typically lawyers would look at it, decide whether or not there were good arguments to say that the insurance company was wrong and that there should be coverage. We've seen a number of arguments that are developing. We've talked about them very briefly here. And then after a period of negotiation with the insurance company, then there's a lawsuit filed to determine coverage. But this is not a traditional coverage dispute, and there's a lot of moving parts. One of those moving parts is that there's already been quite a few number of lawsuits that have been filed. And many of those lawsuits have issues that may determine, if there's a ruling in one case, it may determine the outcome of many, many other cases. And so it's an opportunity for some policyholders to watch and see what happens rather than rushing to litigation. That may or may not be the answer for every business. We have a number of folks that we're working with for whom it does make sense to watch and see what happens. There's another group that we're working with who have to think harder about whether or not they want to pursue litigation. One of the considerations is a relationship with the insurance company. So, for example, one of the folks that we're working with is operating in an industry in which it is difficult to obtain reasonably priced insurance. And while there's not really a real concern that the insurer will just drop them all of a sudden, as a practical matter, there may be a concern that going forward, the insurer may either not re-renew them or increase the premiums going forward, so that the value of pursuing a claim right now has to be weighed against the value of losing the benefit of low premiums that they currently enjoy. And I want to close with one thought, and that is to repeat what I said earlier about read the full policy, because whether or not any of the arguments that we've talked about may apply, or you may have something to look at with your attorney, may depend on the specific language in your policies. The last thing, this is kind of a bonus round. I was talking to some of my colleagues, and we thought that we would also just briefly mention a number of other issues that we see coming around the corner as a result of the conditions that we're living in right now. Related to insurance coverage, we have the potential of personal injury claims by customers and employees. An example of this would be the lawsuit that was filed against Princess Cruise Lines for allegedly not taking sufficient steps to protect people from contracting COVID. We suspect that there may well be claims coming down the pipe against businesses by customers and employees making the same kinds of allegations, particularly if you're in a retail or consumer-facing business. It's something to be thinking about. It raises an issue whether or not your insurers will be providing coverage. Some of the analysis may be similar to what we've already talked about, but coverage under circumstances like this would more likely fall under your general liability policies, and the terms on those policies can be different. One of the issues that we're seeing being floated among businesses and government right now is whether the government should be moving to provide business owners who reopen some sort of immunity because we want to incentivize economic activity right now. And it makes sense that we want to provide business owners with some protection against lawsuits based on contracting COVID, particularly when folks are doing everything they can to protect each other and keep each other safe. Another issue that we've already seen developing in many cases are contract disputes. The rarely used, at least in my lifetime, doctrine of force majeure, an act of God for an unforeseen event out of your control that made it impossible for you to perform. So far, we've seen a lot of folks using common sense to figure out how to get through this, understanding that running to the courts is often doesn't provide a good answer in the best of times. And right now, with limited access to the courts anyway, figuring it out is a good way to go. But we have seen people sort of starting to draw lines as well, and figuring out where responsibility lies. Interestingly, there was a decision last week or the week before here in Chicago by the federal court that required I think it was a cleaning company who was not getting paid by a nursing home and tried to get out of continuing to provide services despite not getting paid, and the court required them to continue providing services, and that's a fairly rare decision. It's very rare that you see a court require someone to continue doing something without getting paid. Another issue, this arises in the context of a Zoom call. So for example, the one we're doing right now, and that is making sure that if you are a business operating with trade secrets, that you're doing what is necessary to protect them, not just from exposure, but remember, if your trade secrets are exposed, they're no longer trade secrets. The legal protection for a trade secret is the fact that the business takes steps to protect it. And so as there's more remote access going on and folks chatting over unsecured channels, it's important to keep that in mind. So if Zoom has security vulnerabilities that are being exploited and there's a discussion of trade secrets, it's once the cat's out of the bag, it can't be put back in. So if you are working with those things, make sure you're taking steps to protect them. Very recently, we've seen an uptick in Paycheck Protection Program litigation. Many small business owners were left out of the first round of funding, and we're really upset to learn that a number of large businesses apparently participated in that and received benefits, and also that some of the banks allowed customers to cut to the front of the line, or at least that's the allegations of some recently filed lawsuits. There's one filed here in Chicago against JP Morgan Bank and Ruth's Chris Steakhouse, essentially alleging that JP Morgan allowed some of its clients to jump to the head of the line while other small businesses were left without access to the funds that they deserved. The last thing that we're starting to see are partnership disputes and business divorces as a result of the difficulties imposed by the economy at the moment. And times are always tough when businesses are falling apart or having a hard time keeping it together. I have a happy story here, though, which is that I was at the outset of all this, I was talking to a potential client about suing his business partners. And what actually ended up happening was that once the Paycheck Protection Program became available, they sought financing, and as a result of that financing are now working to keep their business together, where they had been at each other's throats and really quite close to litigation. So that's one happy note, and I hope to see more of that. That concludes my presentation for today, and I'd be happy to take any questions or comments, concerns that anyone has, with the caveat being that I will try to keep my answers at a general level. If folks have specific questions, we should probably take that offline or contact your own counsel.
Hi, Leonard, this is Reba Osborne. I'm the Director of Government Affairs at the Chamber. I joined the conversation late, and I totally apologize if you touched on this before, or if this is even in the arena. I know there's the workers' comp changed I had like an emergency rulings that made if you're an essential business and your employee contracts the virus, it will be automatically assumed it was contracted at work and it's a workers' comp filing. I know the Illinois Retail Merchants Association is filing a lawsuit. Is that something that's been on your radar?
Yeah, I was aware of that change in the law that made the workers, essentially there was a presumption that you contracted it at work, which I thought was obviously a very worker-friendly proposal.
Yeah.
And at some level, folks want to make sure there's coverage for that. To the extent that it focuses or relates to business interruption here, there was a point that usually lost business income will continue to pay for your workers' compensation premiums. So it's related in that sense. Otherwise, they're kind of two separate issues. Ultimately, it depends on who's going to pay for this, right? If you stop paying your workers' comp premiums, that's going to be an issue, and the carrier may or may not be on the hook for it after that.
Well, that's very, very interesting. Yeah, I just, because I think that would be very financially burdensome for the employer, given that it's a pandemic and nothing that's like neglect of their own, that they're, they're in good faith trying to protect their employees. I just think that it's kind of an undue liability for the employer. So I just wondered if that's come on your radar with any other groups looking at litigation.
Yeah, I haven't seen any particular litigation on that, particularly business groups looking to challenge that provision. The presumption, as I sit here, the notion that there's a presumption, I think, why have a presumption when you can just have the facts?
Good. Wonderful. Sorry to take up your time. Thank you so much.
Thank you.
Appreciate that.